All right, Val, I think it's on you.
Okay, perfect. Good morning, everyone. Thanks for joining us here in today's webinar. My name is Val Arndt. I'm the marketing manager here at Olsen Thielen, CPAs and Advisors. So we've partnered with our friends here at USI Insurance today for a special session. It's going to be focused on the new state employment laws that have recently been passed here in Minnesota that are either currently in effect or they're going to be going into effect in the near future. So our goal for today is to inform you about these new laws and also offer some initial guidance on next steps to help you ensure you're compliant with the new regulations. So we have a lot here to cover today. We'll be touching on all 13 of the new laws, but we do encourage you, if you have any lingering questions, following today's session, or you really want to get that conversation started and discuss more about how a particular law change affects you, reach out and work with your trusted advisor on that. So again, we're very grateful to James for his expertise and to USI for helping us coordinate this and partnering with us here this morning to put on this really valuable webinar. And we're looking forward to the discussion. So over to you.
Thanks, Val. I wanted to just introduce a little bit of USI to give you a little background. USI is the fourth largest privately held broker in the US, named top insurance employer 6 years in a row, so we're very proud of that. Our 10,000 plus employees spread out over the United States with over 200 local offices. We are located, myself and my colleague Clyde and James are all located in the Bloomington, Minnesota office. Nationally, we have over 500,000 clients. So that's unique in a way that USI does gather and use data in making decisions for our clients and proposals and thoughts for our clients. So everything is collected and data is saved. So it's really a unique proposition. But I wanted to say one of our unique services that we do provide for our clients is our HR solutions team, in which James does head up. They're a resource for our clients for everything HR related, which is very unique in my industry. And one of the critical pieces that is topical right now is the Minnesota law changes. So James is going to have a very interesting presentation on that. So James?
All right, thanks, Rob. I will point out just one last thing that I should know about USI. So we are an insurance brokerage agency. We broker both employee benefits, but we also broker P&C as well. So, your workers' comp and your liability insurance too. So if you have needs in those spaces, we do hope that you reach out to somebody at USI because I know that we can help you. Couple things by way of introduction. I'm going to give you a bit about my background just because I think it is germane to what I'm going to be talking about. Plus, and this will give you a sense of how the rest of our time together is going to go. There are three things that are true and unavoidable in life. The first of those is death. You, all of you, and frankly me, we're all going to die, which is a very morbid way to get this thing started, I suppose, if I'm thinking about it. But it's true. We're all going to pay taxes. That's the second thing that's true. All of us are going to be doing that at some point or another. And the third thing, and the one that is most relevant to me personally, although I both will die and pay taxes, is that if you give an attorney the opportunity to speak about themselves, they will never pass up on that opportunity. And so I'm going to talk about me for a second. I was in private practice for about a decade before taking this job, and I did that as a plaintiff's attorney. So my job was to sue folks just like yourselves on behalf of your clearly undeserving current and former employees. Since 1999, I've worked for USI or some version of USI in the same capacity that I've got now. I'm part of a team of employment law attorneys that have HR and risk management backgrounds. We work directly with our clients, try to help them navigate stuff like the legal changes we're going to talk about, but also anything really having to do with having employees and the problems that they create. So where it's applicable, I will also try and share some stories that I've gathered from clients over the years too to help sort of explain some of the points we're going to be going through. But that said, we have a full slate of things to talk about. Couple of administrative points. Administrative point one, and Val mentioned, if you've got questions, put them in the chat function. I'll try to keep an eye on that. There was a lot of interest in this particular presentation, which I would like to be personally flattered by, but It really doesn't have anything to do with me. I'm guessing it's the legal changes. We'll see if I can make you love me by the end of this. Maybe, maybe not. But because there are so many people who have decided to be part of this, and again, I'm grateful for that. If there's just an overwhelming number of questions, we just won't be able to get through all of them in time. So keep that in mind. I'll try to stay abreast of those things, but if you guys have a ton of questions, just recognize we have a finite amount of time to go through a significant amount of information. And the second thing is, in follow-up to today's presentation, I believe that Clyde and Rana will be sending you emails that have copies of this slide deck. So if you're looking for a copy of it, that should be coming in PDF fashion after today's session as a follow-up. So that way, you'll have a good reference guide to the stuff that I'm talking about. All right, let's get to the materials in chief. We're covering 13 things today. I have got them listed here in basically effective date order, and that is also the way we're going to go through them in the presentation itself. I'll start off with it's not an editorial observation, it's an observation of fact, not edit. So with this recent significant onslaught of changes, the pendulum swing at the governmental level is exactly what you think it is. Whoever holds the office of the governorship, whichever party does, and then the two houses of Congress, the Senate and the House. This is true at the federal level and also within Minnesota. Whatever party controls, if they ever control all three, then they can get through a whole bunch of laws that are specific to the platforms that they all campaigned on. For the first time in many years, the Democrats have had control of both the House, the Senate, and the governor's office in Minnesota. And that is why in this recent legislative session, we've seen such a significant number of new laws come about, many of which impact employment, but many of which go well beyond employment as well. So we're going to focus on the employment-based laws. I'm also going to say this now, but I will say it again when it's appropriate in specific sections. There are certain things for the laws that haven't yet gone into effect. ESST, Earned Sick and Safe Time, is one of them. Paid Family Leave is another. There's a lot that we don't know. I know exactly what the law has, the statute says within it, and I will share that with you. But we expect a lot of guidance to be issued by the state and the various agencies within it in the run up to those things actually going into effect. So some of these things are as much as we know today, with the understanding that that knowledge is likely to be nuanced and supplemented by things that the agencies will be issuing in the following months and years. So these are the things we're going to go through. I can read them to you, but that's not that interesting. Let's just get into the actual substantive ones. The first of them is something that took place outside of the legislative session. Well, sort of. It happened well before the legislative session came to an end. It's something called the Crown Act. So, and by the way, I'll actually note one other thing too. For any of you that are a multi-state employer, and so this is maybe a good sort of starting point. The laws of the state in which your individual employee works are the laws that are going to control the rights and responsibilities of that you have for that employee. So for instance, if you're headquartered in Minnesota, but you've got 3 people working in Colorado, even though your headquarters are here, Colorado law is going to dictate what rights and benefits those employees in Colorado are entitled to. I mention that because several of the laws that we're going to be talking about are part of larger national trends. At the federal level, the president and his administration are trying to pass a lot of laws that are similar to some of the ones you see here. Federal Congress can do nothing other than fight and point fingers and do things like that. And so at the federal level, we're not likely to see these things become laws anytime soon. There are some pernicious ways that the president can use agencies to effectuate some of this stuff for federal contractors and whatnot, but that's not the purpose of our time together today. At the state level, though, many states are also passing laws like the things you see here. The Crown Act is one of those things. But you'll see that also with Earned Sick and Safe Time. You'll see that also with Paid Family Leave and some of the other stuff that's on here. I mention that because as a multi-state employer, if any of you are, your employees in states outside of Minnesota generally aren't going to have to worry about or are going to be protected by the laws we're talking about today. But it is just, depending on what states are in, they may already have some laws that look this way, or they may soon have laws that look this way in those states as well. So this is part of kind of a groundswell of focused efforts across the country. So let's go back to the Crown Act. So as you guys may know, under federal and state law for that matter, there are what are called protected categories or protected classes, age, race, gender, disability status, sexual orientation, national origin, veteran status, etc. All those things that you guys recognize to be protected. And what those laws say is that generally you cannot discriminate against somebody who has one or more of those protected characteristics. You can't discriminate because of those characteristics. Race is one of those characteristics, as you all know. The Crown Act is expanding the definition of race so that it now includes exactly what I've got written. And this is actually from the statute itself. Race is inclusive of traits associated with race, including but not limited to hair texture and hairstyles such as braids, locks, and twists. So a couple things. One of the reasons that change has been made is just to make it crystal clear. There are some employers that will require people with sort of race associated hairstyles to either cut that hair or to cover that hair or do certain things. And so this is just basically saying, look, race isn't just the color of one's skin, it's also the things that may be reflective of or endemic to that particular race. So what does this mean for you guys? The net balance of it is it probably isn't going to change your practices in any significant fashion. Hopefully you weren't discriminating on this basis already. If so, stop it. But what it does mean is that any policy you have in a handbook that lists or identifies any of the protected categories, such as race, you should change your handbook policy by putting a parenthetical after the word race to include the language that I've got here. So like your harassment policy probably has a listing of protected categories. If you have an EEO policy, that probably has it. If you have an affirmative action policy, that probably has it. So again, just go and make sure that you tweak your handbook to reflect this more expansive definition of race. The next thing on this is not something that's likely to change your practices at all. It is just a curiosity, but it's actually part of a national trend as well. So a new statute was created that basically says that any settlement given in the context or in connection with sexual harassment or sexual abuse in the workplace is now not taxable, basically. It's going to be not paid as a true severance or paid as wages, so it's going to be a non-taxable settlement event. Now, for most of you, you're not probably paying out a whole lot of settlements in this space, so, who really cares, right? Or at least hopefully or not. But there are some things to think about, though. The statute is incredibly unclear what it means that and by the way, this is a state tax-free thing. It would probably still be taxable for federal purposes. So you've already got sort of a weird disconnect right there. What's not clear from the statute, and frankly may never be clear, I don't know that the agencies will be issuing any guidance on this, but we'll see, is what about a global settlement? So if I'm giving you a severance agreement because I'm laying you off or I'm terminating your employment and I want to buy a release of claims from you, well, you've never had, say, a harassment complaint against us, so that's not ostensibly why we're doing this, but those global settlements always include sexual harassment and all those sorts of things too, in addition to disability harassment and discrimination, race, etc. Does that mean that part or some of that settlement or payment that goes in connection with that severance agreement is going to be tax-free? I don't know, maybe. What constitutes a settlement? Is just offering that agreement as a whole, is in connection with a broader layoff? Is that a settlement per se? So it's one of those things to say, I don't know this is going to change your day-to-day practices, but if you do find yourself using one of those types of agreements, a severance or separation and release agreement, especially if you're trying to pay or buy off somebody's potential threat to sue you, consult with someone like me, talk to your lawyer basically to figure out, is there going to be a tax consequence that you need to be mindful of in connection with the payment under that agreement. So next, Minnesota Parental Leave Act and wage disclosure, two separate laws, but I'm including them on the same slide because the changes to each are relatively minor, but in one case, very significant. So let's start with the MPLA, which is the minor/significant one. So the Minnesota Parental Leave Act, for those who aren't actively thinking about it, is very similar to, in one limited or narrow respect, the Family Medical Leave Act at the federal level. And what it provides for is up to 12 weeks of time off in connection with the birth or adoption of a child. Under the old version of the law, there were some caveats or limitations or hurdles that had to be passed in order for coverage to be extended. The first of those is that employers, not all employers were covered. If you didn't have any locations that had at least 21 or more employees at them inside of Minnesota, then you just weren't covered. No employees had any rights because you didn't have any facilities large enough to actually trigger the responsibilities of the law. The second limitation was one on employees. And that is, in order to have rights, I had to have worked for you for at least 12 consecutive months and at least one half of your full-time schedule. So if you have 40 hours as your full-time schedule, they have to work at least 20 hours on average per week to be covered. So those were some of the limitations, and that 12-month waiting period is kind of similar to the Federal Family Medical Leave Act, which also has essentially a 12-month waiting period from my date of hire before I get to be covered, with some limited exceptions. So given that, that's the old law. The new law takes away both of those restrictions. Every employee is covered and every employer is covered, period, full stop, from the first day of employment. That's a big, big deal. Because if you think about it, let's say that you hire me and I get pregnant on or about the date you hire me or shortly thereafter. Normal human gestation being 9 months. I have my baby 9 months after that. I take my 12 weeks of Minnesota Parental Leave Act leave, which normally I would have no access to because I wouldn't have worked for you for a year. So I do that. Once I hit my anniversary date, which is about the time I would come back from my MPLA leave, magically now, assuming you're large enough, I have FMLA protection. So I have another guaranteed job protected leave right of 12 weeks to take off for the birth of that child for 24 continuous weeks of time potentially. Because the time that you give me in my first year of employment cannot be counted against my subsequent FMLA once I hit my anniversary date. So this is kind of a big deal. And for smaller employers that weren't covered by the MPLA or the FMLA at all, now you are. Now, why is this happening? It's happening because, and we'll get to this, the very last thing we're going to talk about is Minnesota's paid family leave, which goes mostly into effect 1/1 of 2026, is an anticipation of that. And I'll explain why when we get there, but it's gone into effect already, which means that you're going to have to change your policies in your handbooks if you have an MPLA policy, which you probably should. And then secondly, you're going to have to change your practices. Recognize people in their first year of employment are now going to have rights of access to job protected leave in connection with the birth or adoption of a child. And that right extends to both birth parents and non-birth parents. So recognize it's not just the person who's physically bearing the child, it is also the person who is the other parent in that relationship. So that's a pretty big deal. Even though it's a small change, the impact is very significant. Wage disclosure. So you guys may recall that, back in 2018, maybe it was, there was a big sort of seismic change in what were called wage theft laws. So Minnesota's always had some wage theft laws. Most states do. You can't steal wages from your employees. Duh. But what Minnesota did was it also imposed a bunch of other obligations, such as providing a wage theft notice, providing wage change notices, providing additional information in pay stubs. There's also some additional penalties that are out there. So what I'm showing you here is a change that went into effect with respect to the wage disclosure statements that went into effect on 7/1 of 2023. This is actually a copy paste from the statutory language itself. For those that aren't familiar with how these things work, when changes are made to an existing law, underlined language is the new language the legislature has added into the existing statutory language. The existing statutory language is the words you see in here that have no strike throughs and no underlines. A strike through means that there was an existing provision within the existing law that is no longer part of the law going forward. So strike through, underline. So there's not a huge change here. I mean, if you read, the old law said an employer may not retaliate against an employee for asserting rights or remedies under this section. If somebody demands a copy of their wage statement, if somebody makes a wage theft allegation, you can't retaliate against them for having done so. The new expansion just says employers shall not discharge, discipline, penalize, interfere with, threaten, restrain, coerce, or otherwise retaliate or discriminate against an employer for asserting rights or remedies in this section. I would make the argument that substantively, that's not a big change. It seems to me like it's not that big of a deal. What I take this as is the legislature sort of giving the nod and the encouragement to the Minnesota Department of Labor and Industry to ramp up their efforts to do enforcement in this space, to do audits and investigations to make sure that employers are doing their wage theft notices correctly, that they're doing their wage change notices properly, that their pay stubs have the things they're supposed to have in them. Point being, I suspect there's a greater chance that you're going to have the Minnesota Department of Labor and Industry knocking on your door to say, hey, show us what you're doing in the space, and then potentially being subject to penalties or consequences if you're not doing what you should be. All right, moving forward, two other changes that also went into effect on July 1st of 2023. The first of those is breast milk expression revisions. quick sidebar here. So there's a federal law that gives women the right to take break time during the course of the day to express breast milk within a year of the birth of a child. There was a Minnesota law that already said that and was a bit more expansive. That Minnesota law originally said that unpaid time could be given for this purpose, or women are entitled to unpaid time for that purpose. Effective 1/1 of 2021, that nursing law was revised in Minnesota to say the time now has to be paid, not unpaid. So there's already a change. And then what you see here is the most recent change to the statutory language. And again, the strike-throughs are the language that was eliminated from the existing statute, and the underlined word is the one that was added. So what's the change here? So basically, and I don't know why the legislature did this, but you can see the first strike-through is the word breast. I'm not entirely sure what other forms of milk can be expressed by a new mother. But apparently the legislature feels there must be something, and so breast is no longer going to be within the statute. It also, more importantly, deletes the 12 months following the birth of a child language. So before that, I had the right to take this time off to express breast milk, it's just milk, for up to 12 months post-birth. That 12 months is removed now. So if I want to do this for 2 or 3 or 4 years, not in theory, in fact, I have a legal right to continue to do so in perpetuity. I doubt there's the concept of a wet nurse much anymore, but presumably, and it has to be for your own child, so it can't be for others. I suppose the wet nurse is a bad example. Anyway, point being that is a change. Also, it says previously that the time had to run concurrently with break times already provided to the employee. That has been sort of softened to say break times may run concurrently. So you cannot require necessarily that they have to be run concurrently with existing break times. And the old law used to say, hey, if letting you do this is going to create an undue hardship, we don't have to give you that time off. That undue hardship language has now gone away. So if, for instance, you've got a production line, and that production line has to have all 5 people on it working all consistently for as long as the machine's running. If any one person steps away, the machine has to be shut down, and now you've got 4 people sitting idle. That may have to be the case now, because people have a right to do this, and you cannot deny them that opportunity to take this time. So again, you'll probably want to tweak your policies and your handbooks to the extent that they talk about this particular right, to make sure that they're consistent. And secondly, you may want to change your practices with respect to how it is you grant or deny requests to take time off to express breast milk. Similarly, at the federal level, there is now a protection that gives pregnant women the right to accommodations in the workplace to accommodate the needs of their pregnancy. Minnesota had a law like that going back, I think, to about 2018, so several years before the federal law was changed. So Minnesota's law has now been expanded a little bit. This isn't a huge change, but it's just, I think, also sort of identifying, I think you're more likely to see enforcement efforts in this space than we have historically. And so the changes, as you see, again, underlined is new language, strike through is getting rid of existing language. So what they're saying is that the accommodations, the examples they give of those accommodations include now not just seating, more frequent or breaks and limits to heavy lifting, but also now temporary leaves of absence, modifications in work schedule, job assignments, and now longer break periods as well. I don't think that's changing the posture of how you guys are going to function as an organization. I'm just pointing out, if you've got a woman who's pregnant and she comes in with some sort of lifting restriction, you're probably going to have to accommodate her. There are a few limited kinds of accommodations under the existing law. This isn't a change. This has been the case since Minnesota passed this law, that you can't actually say no to, you can't claim an undue hardship for, and you can't request medical confirmation of. The 3 of them, very quickly, one of them is more frequent rest breaks. The second one, I think, is the opportunity to sit and stand more, throughout the course of the day. And the third one is if I have a lifting restriction of 20 pounds or above, so I can't lift 20 pounds or 25 or 30, for instance, you have to give that to me, period, full stop. You can't ask for doctor's confirmation. You can't say no. You can't claim undue hardship. If I have a lifting restriction of under 20 pounds, 18, 15, 10, that you can say I need a doctor's note, that you can potentially say no to, but anything above that, you can't. And that's kind of a big deal, depending on what you guys do as a business. If it's white collar work, who cares? But think about construction work, or a lot of machining work, or personal care assistant or attendant work. If I go into somebody's home as a PCA and I have to help toilet and untoilet somebody or help them up off the ground if they fall, they weigh more than 20, 25 pounds. I don't know how you comply with that. So point being, we see some nominal changes here. The big thing that's going to be a change to your actual administrative practices is that the law now requires, both laws do, they didn't before, that employees be provided with a formal and official notice of their rights. The Department of Labor and Industry, if you Google it, has in fact created a sample notice. It has to be provided to employees at the time they're hired, upon inquiry. So anytime somebody says, hey, I may need an accommodation for my pregnancy, or hey, I may need to express breast milk, or I'm just curious about what my rights might be, you have to give them that notice then too. You have to do it when they're actually requesting the covered leave or accommodation, and you have to include that notice of rights and remedies, the Department of Labor and Industry's created language, in your employee handbook. So get the notice, put it in your handbook, make sure you have it available to provide to people electronically or in print fashion, upon the occurrence of those things you see listed in the bullet points. So that is going to be a change to what you do. The basic rights that people have aren't changing that profoundly, but a little bit at least. All right, let's switch tack to something that I think is a little bit more of a change for folks going forward. Any of you who are currently using non-compete agreements in some fashion or another, and quick pause point here, a non-competition or non-compete agreement is something that historically the Minnesota courts in particular, and a lot of courts across most states, have viewed with great disfavor. And that's because a non-compete agreement interferes with the at-will right to employment that I as an employee have. I have the right to go work for whomever I want. That's my legal right as an at-will employee. I don't have to keep working from you. But if you give me a non-compete, you're actually taking away from some of the rights that I have. And so courts have imposed a lot of restrictions in that case. Several states already have prohibitions on non-compete agreements. California, Illinois, I believe New York has some. I'm blanking on a few other states. Point being, Minnesota is now one of them. You can no longer use a non-compete agreement in Minnesota effective July 1st, 2023 and going forward. But notice I said going forward. If you have an agreement that was signed prior to that, the previously signed agreement can still be enforced. Now, again, the courts didn't like them in the first place, so there's always a question mark as to whether it would be enforceable in the first place. But prior to July 1 of 2023, non-competes that exist are still enforceable. Anything from that point going forward, new hires, midstream employees, whatever, you just can't use them. That said, I will point out, and by the way the law phrases is it's a covenant not to compete. And so it's basically preventing somebody from working for another employer for a specified period of time, or working in a specified geographical area, or working for another employer in a capacity similar to the one that I have for you. You can't prohibit those things. So do you guys need to care about this? I think you do. You got to take those provisions out of your existing agreements, using them going forward. So that's something you must do. But I don't know that it's going to have that big of a substantive impact, because by and large, most of our clients don't generally care who you go work for. Some of them do, but most of them care, hey, don't use our confidential and proprietary information. So we want to restrict you from doing that. Don't try to poach our clients, our prospects. Don't try to poach our employees. So really, it's non-solicitation, confidentiality, and non-disclosure that are more the actual interests that our clients have in this space. Those are still perfectly legit and sound. You can still use those kinds of agreements. You just can't also include a non-competition prohibition as well. So it's a long way of me saying this is a big change and it's a big deal. But I think the net effect is that for most of our clients, and probably for most of you, it may not be that big of a deal, because you can still use the stuff that you were probably most likely to leverage in the first place. So just keep that in mind. Recreational cannabis, this is a big deal. There are a whole bunch of parts of this law, most of which we're not going to talk about, but we're going to talk about the three things that directly impact employment and some employment practices. So as a level set, and telling you guys something you already knew, in Minnesota prior to 8/1 of 2023, which is essentially when recreational cannabis became legal here in Minnesota, medical marijuana and gummies were already legal. So there was already some incursion of basically marijuana related types of things that were consumable and legal in Minnesota. Now, going forward, all forms, basically, of cannabis will be legal for recreational consumption. It does beg the question whether anyone's going to bother with medical marijuana cards ever again, but maybe. So given that, now it's all legal. What does that mean? We've had a lot of clients that have called us in a very sort of Chicken Little way. The sky is falling. The sky is falling. Our employees, they can now smoke weed during their breaks. They can smoke it in their cars right before they come into the workplace. They can have it on their person while they're working. It's a no holds barred, whatever. No, just because it's legal doesn't give people rights to do whatever they want with it. Think about alcohol. Alcohol has been legal for, well, ever before Prohibition and then briefly not, and then after Prohibition. You guys don't let people carry open bottles of booze in your workplace. You don't let them drink, during their work breaks. You don't let them drink before work and come in hammered. You can regulate possession and consumption and impairment in any ways you see fit. Just because it is legal does not change your right to do those things. So for those of you who are, and hopefully none of you are, engaging in some kind of hysteria in connection with this, take a deep breath. You still have some control. But let's talk about the three things that are changing. Thing number one, criminal code is changing. Low-level drug offenses involving marijuana, whether that's possession, whether that's paraphernalia, and several other things, those convictions are going to no longer be, that's no longer criminal. They're going to go away. And people with those convictions are supposed to have them expunged. So they're not supposed to appear in the criminal records anymore. So what does this mean for you guys? Probably not criminal law firms, most of you, so what do you care? Well, if you're using criminal background checks at all as part of your hiring, onboarding, or ongoing employment practices, do recognize if you see those convictions appearing on somebody's background checks, even if they're expunged, they still sometimes show up. You're supposed to ignore them. That's going to change the standards that you guys utilize potentially in your pre-employment criminal background checking processes. So you may need to make changes there. The second law that was changed is the one that people most probably automatically think about is drug testing. What does this mean now for drug testing? Are we hand-tied from ever using marijuana, impairment due to marijuana as a reason to discipline or do something in the context of the workplace? Now, before I get into the details that are on the slide, let me make a preemptory sort of observation. Minnesota has one of the strictest sets of drug testing laws in the country. And it has for years and years and years and years and years. For instance, if you drug test somebody, they come back positive, somebody who's an active employee, you test them on reasonable suspicion or something like that. You can't fire them. You cannot fire them. You actually could fire them if you just suspected they were impaired and then didn't test them. You can fire then, but you can't fire once you test and they wind up testing positive. Instead, you have to give them the opportunity to meet with a chemical assessor and then complete whatever drug rehabilitation program may be recommended by that assessor. It's kind of a big deal, actually. Okay, so what does that mean in the context of this? Well, there are sort of 5 different versions of drug testing that are permissible in Minnesota. Pre-employment is one of those, which we'll talk about in a second. Reasonable suspicion is another, which also includes, by the way, post-accident is a subset of that. Random testing and then post-treatment testing. Those are sort of the authorized forms of testing that exist. And so pre-employment is the one that's most affected by this change to the Minnesota drug testing laws. Essentially, what the law says is that pre-employment testing cannot screen for cannabis. Or if it happens to still be on the drug testing panel, you have to ignore the results. However, there is a great big exception to that. The exception is for the things you see listed here in the sub bullet, safety sensitive quote unquote positions. Now, there is a definition of safety sensitive. It essentially is any kind of position where if I were impaired and my impairment might increase the risk of me causing harm to myself or to others, and if I'm operating a forklift, for instance, or I'm operating some kind of drill press or whatever else, I'm driving a vehicle, that's a safety sensitive type position. So you can still include cannabis on your pre-employment drug testing panels for safety sensitive positions. And then the other ones you see here too, peace officers, firefighters, direct care providers, people providing direct care to children, vulnerable adults, and certain kinds of patients, commercial driver's license positions funded by federal grants, or positions required to test under some other state or federal law. So if you have DOT drivers, for instance, for whom drug testing is a mandatory requirement as a condition of employing them and letting them drive for you, you can still include cannabis on that. Cannabis is still illegal at the federal level. The DOT drug testing requirements will trump the state's restrictions. Driving a vehicle, frankly, safety sensitive anyway, so whatever. But just as a quick pause point, actually, one other thing in the testing that I'll make my editorial observation. You can still include cannabis in your reasonable suspicion, your post-injury accident testing, all those circumstances outside of pre-employment when you probably otherwise would have had it in there anyway. So the restriction is relatively narrow. You can't, for instance, include cannabis on a pre-employment drug test for an office staff person. I mean, there's just no safety sensitive element to what they're actually doing there. Or to professionals, for instance, generally you don't get to do it for them either. You might not have been doing it before that, but still you can't going forward. But safety sensitive is a pretty broad loophole. I will say as a sidebar, pre-employment drug testing, if you're doing it now, it is a conversation you should be having quite apart from this change to the law. I have found that historically most of our clients who do pre-employment testing they don't catch the people who are, doing meth or cocaine or heroin or whatever, the hard drugs. The only people that get testing positive are people testing positive for marijuana. And that's because marijuana stays in your system for up to 30 days, essentially, give or take. Whereas things like cocaine, marijuana, meth, all the rest of them get out of your system in 48 hours or less. And so it's easier to pass a drug test if you're a heavy meth user by just stopping using meth for 2 days before the test itself, and then you pass the thing. Whereas if you smoked some marijuana over the weekend 3 weeks ago and haven't smoked since, you still are probably going to test positive. Anyway, that's not a legal thing. That's just if you're going to do pre-employment drug testing, make sure you know why you're doing it. The last of the three sort of changes to Minnesota employment-related laws that exist here are around Minnesota's lawful consumable products law. Now, most of you probably aren't familiar with that. So Minnesota, and there are a number of states that have protections sort of like this, has for many years had a protection for lawful consumable products. Historically, that has always meant alcohol and tobacco. What the law basically says, historically, and still continues to say, you cannot discriminate against somebody because they smoke tobacco or consume alcohol. Now, that doesn't mean you have to allow them to smoke during the workday or drink during the workday. You can regulate that behavior in the workplace any way you see fit, but you can't say categorically, we don't want to hire smokers or we don't want to hire people who drink. Now, just as a quick sidebar, why would you want to do that anyway? Well, with smokers, for instance, they're more expensive for you on your health plan. A ton more expensive because of all the health risks that are presented by smokers. Same thing, frankly, for smoke breaks. People take smoke breaks all the time. That can be impact into the work that they're doing. So you can see why people might want to prohibit that, but you can't. You can regulate the behavior in the workplace any way you see fit. You can't smoke during the workday. You can't smoke during your breaks. You can't smoke in your car over lunch. But you can't say you can't smoke at home on your own time. Cannabis is the same way. You can regulate it any way you see fit, but you can't say we're not going to hire people who choose to smoke marijuana on their free time, for instance. So we've got a question here. If an employee is issued a company vehicle and required to drive daily, but not DOT, could that be still considered a safety sensitive position? I think absolutely. Because if you think about the standard that I very quickly rattled off, a safety sensitive position is one where my impairment, should I be impaired by, in this case, cannabis, could lead to an increased risk to my own health and safety or the health and safety of others. If I'm driving, my car is what, 4,000 pounds nowadays, just my own vehicle or more. If I'm driving that thing, that's a safety sensitive position. So yes, I think somebody who drives is part of their job. Now, commuting is not driving for work purposes. So if that's all I do, if I'm a receptionist, I commute to work, well, that's not driving for work purposes. But if I am a salesperson, I'm going out and meeting with prospects and all the rest of it, sure. Or I'm a courier for you or something like that, then yes, I think that would be safety sensitive. Okay. And then the last thing, like I said, lawful consumable products has changed, but you still get to regulate the possession and consumption and impairment any way you see fit in the workplace. So take a deep breath. There are big changes coming when it comes to cannabis, but most of the rights you have as an employer, for the most part, continue to exist. Okay, the next one here is employer-sponsored meetings, and then we're going to get to earned sick and safe time, which is what I think a lot of you are going to care a lot more about than most of the things I just talked about. So We've got another question here as well. With post-accident testing and knowing that marijuana can stay in the system for 30 days or so, I struggle to penalize somebody for something they may have done 2 weeks ago. Thoughts? Question mark. I 100% agree. I I think unless you're doing reasonable suspicion testing, so somebody is obviously impaired in front of you, I've never been a huge fan of including marijuana on the pre-employment drug testing panels just because of the latency effect. I don't know that it's really dispositive of very much. Somebody who tests positive for cocaine, meth, or heroin, just using those three again, that's it's a bigger problem for me because again, there's such a short latency period there. So employer-sponsored meetings, the gist or conceit behind this is that it's realistically what is unions were lobbying the legislature to get this passed. So if an employer is going through some union organizing activity, so there's some union organizing that's going on, most employers want to put forth a counter union sort of campaign to educate employees and help them understand, hey, all these magical promises the union is making, they may not be as magical as they're making them out to be. Here are the things you need to know, blah, blah, blah. One of the ways that employers historically have done that is through what are essentially mandatory attendance meetings. All employees need to attend, or at least all employees from this particular division or whoever's considering unionizing, because we want to tell you about the evils of unions or whatever. So what this law is actually saying is it goes broader than that. It says that employees cannot be punished for refusing to participate in meetings or refusing to attend, basically, to communicate the employer's opinion regarding religious matters or political matters. And political matters has a very broad definition that includes the captive audience anti-union meetings. So that's really what this is getting at. You also have to post a notice of rights wherever your notices are customarily placed, or if you have your workplace posters, you're supposed to post a new poster that the Department of Labor and Industry either has recently put together or will be shortly that basically says, hey, you cannot be required to attend mandatory meetings and these, for these purposes. I doubt that's going to impact what most of you guys are doing, but just recognize there's now a new basic posting that's going to have to go up. And if you do go through an organizing campaign, do recognize you can have voluntary participation meetings to talk about the alleged evils of unions, but you cannot make people attend and hear what your positions are about that. Oh, and one last thing. If you have other mandatory meetings for reasons that aren't for religious or political purposes, you can still have those. If you have mandatory safety meetings or mandatory all-employee meetings to talk about, the state of the company or whatever else, you can still do that stuff. It's just religious matters, political matters. Political matters is broad enough to include anti-union information. All right, here's the big one. So coming up in a very few short months from now, we've got earned sick and safe time. Now, for any of you who have employees in Minneapolis, St. Paul, Duluth, or Bloomington, you have already been living with some version of this law. So, if you are exclusively situs in one of those four cities, this isn't going to be a huge change for you. For everyone else in this call, it's going to be a very big change. So what is it that this law says? And again, as I mentioned earlier, this is part of a larger national trend. A lot of different states are, and localities for that matter, is usually where they start. It's the way it happened in Minnesota, are passing laws like this. And the conceit is there are certain industries and types of jobs where the opportunity or availability for sick time basically it's non-existent. That's true in some industries. That's true in some, like part-time employees very commonly aren't eligible for things like this for a lot of our clients. This is trying to get to the fact that all of us are human and all of us at some point or another are going to have a need for absence that we can't help or avoid. And gosh, there should be some protection for that and there should be some pay that goes with it. You can agree or disagree with that. I'm just saying that's the conceit behind the law itself. So what does the law say? Well, let's start just basically with the foundational understanding of it. Employees, all of them, with basically no exception, are going to earn. And by the way, I see someone's raised a hand. If you can pop into the chat function, I don't know that because I think everyone's automatically muted as part of this, so I can't call on people. So if you've got a question, pop into the chat function. Employees earn at least 1 hour of ESST for every 30 hours they work, up to a minimum of 48 hours per year. You can allow people to accrue beyond that, but you have to allow them to accrue up to 48 hours per year. Exempt employees, for what it's worth, people are being paid a salary like I am. By the way, the exemption test is more difficult than just paying a salary, but that's not the purpose of today's webinar. Sidebar. Exempt employees will be deemed to work 40 hours per week unless there is some specific written understanding to the contrary. If I'm a part-time exempt employee only working 20 hours a week and you've got that in writing, then you can accrue based on that. And again, you can allow accruals beyond that. So 1 hour of ESST for every 30 hours worked. That's the basic calculus. I believe that's the same formula used by Minneapolis, St. Paul, Duluth, and Bloomington. The time can now one of the differences that we have with the state, and I'll get to Carrie or Kari's question here in a second. By the way, if Carrie, if you're a Kari, or Kari if you're a Carrie, sorry, but I'll get to that question in a second. Time can be used as it's accrued. In Minneapolis, St. Paul, Duluth, and Bloomington, I believe all four of them, you can impose a 90-day waiting period for new hires. So people start accruing it from day one, but you don't have to let them have access to it until 90 days goes by, which I think those cities did because for some positions, there can be a lot of turnover in that first 90 days. And so, you want to make sure people are going to stick around long enough to make it worthwhile to extend this time. The state is not going to allow any 90-day waiting periods or any waiting periods. The second I have an hour of ESST accrued, I have a right to use that time. So that's a big shift for those of you that already are complying with the city versions of those. You're going to have to tweak your practices to now accommodate the state. The time that I use, my ESST covered time, cannot be counted against my attendance. And that is true even if you have a no-fault attendance policy or a points-based approach to attendance. So if you do, you're going to have to change your attendance processes to allow for that. Not until I exhaust my ESST can you then count those otherwise ESST covered absences against my attendance. So that's kind of a big deal too. In other words, it's basically job protected absences, if you will, that goes into this. Some of our clients, particularly in hospitality industries, but also like in nursing and other practices like that, will require employees to find their replacement as a condition of getting time off. Sure, you can call in, but you've got to find a replacement as part of that. You can't do that. The SST law says if the reason I'm needing an absence is covered by ESST, I can't be required as a condition of using it that I find my replacement. You don't have to pay out the time upon termination. You can, but you do not have to. We'll talk about employers who use PTO policies later, so hold tight on that, but it does not have to be paid out on termination. However, if I leave employment and then you rehire me within 180 days, you have to reinstate the balance that I had at the time that I left. If you hire me 181 days or more beyond that, you don't have to reinstate it, but do recognize, while you don't have to pay it out, there may be a reinstatement requirement if you rehire me. And if you go through a merger or acquisition, the unused ESST balance is going to carry over to the new employer for both stock and asset purchases. Quick sidebar here. In the merger and acquisition setting, and this is simplifying it greatly, there are essentially two kinds of acquisitions, stock purchases and asset purchases. With a stock purchase, you're buying all the liabilities and assets of the company, and that would include any legacy obligations to employees. And so in a stock purchase, typically employees are not fired and rehired. They just continue employment under a new name or a new employer. An asset purchase, you're not buying the liabilities. You're just buying the assets. Employees are fired. They're typically then rehired by the acquiring company. You wouldn't have to normally carry over any liabilities except ESST says you do. It doesn't matter the nature of the acquisition, you're going to have to carry over those balances. And then finally on this slide, there are more ESST slides coming up. Time can be used in the smallest increment used by the employer, so long as that increment is not greater than 4 hours. So what does that mean? Take a look at your sick, vacation, or PTO policies. They probably have something that says something like the following. Exempt employees can use PTO in minimum increments of, say, 4 hours or 2 hours, something like that. Non-exempt employees can use a PTO in minimum increments of 1 hour. You're just basically saying, what's the minimum amount of time that block of time you can use PTO and or sick or vacation? You can set those same kinds of restrictions for ESST so long as the minimum block is not greater than 4 hours. So if you have an existing practice, you can continue to apply that practice subject to that 4-hour limitation. Okay, a couple of questions here I'll do quickly. How does this affect companies that have employees that live in another state, but employees are working or could work in Minnesota? So this time accrues on time physically worked in the state of Minnesota. And so if it's not being physically worked in the state of Minnesota, then it's not going to have time accrue. The SST is not going to accrue against that. If you're using a PTO policy to cover this, which we'll talk about later, then that is probably going to be a different calculus for you. Next question, if you have employees that receive 120 hours of PTO per year, do they also get ESST time? Sit tight, we'll get to PTO because that's a much, much more nettlesome or vexatious subject matter area, but I'll address that when we get there. Is there a minimum company size? Nope. Everybody and everyone's invited to the dance. Everyone has these rights. So let's move on here. Employers also have to keep records of hours worked and ESST used by each employee. So in other words, if the Department of Labor and Industry knocks you over and says, all right, provide proof that you're accurately and sufficiently accruing ESST time, they're going to need to see the hours that each individual that attributable to each individual in your organization and make sure that the rate at which they're accruing ESST or PTO or whatever corresponds with what you should be awarding them. The time can be used for a variety of things: an employee's own illness, injury, or health condition and preventive care, makes sense. A family member's illness, injury, health condition, and preventive care. The next slide will talk about what family member is, and it is a very expansive definition. Leave related to an employee or family member's needs in connection with domestic violence, sexual assault, or stalking. That's the safety piece of it. Closure of an employee's business or a family member's school or place of care due to a weather or public emergency. So if you have an employee who's got kids and the school system is shut down for a snow day, for instance, they have a right to use ESST and can't have it counted against their attendance. And if I have an inability to work or telework due to an employer-imposed quarantine or a health or public emergency sort of declaration, then I can use the time too. It seems unlikely those last two are going to come up a whole lot. Certainly, it's probably those first four, but just recognize those are all the reasons. Here's who a family member is. So a family member includes the kids, which is child, foster child, adult child, legal ward, et cetera, all the things you see in that first bullet there. That makes some sense. But it also includes a child to whom the employee stands or stood in loco parentis. So what that means is, let's say, for instance, that I have a girlfriend, she's got a child from a previous relationship, we happen to live together, I've not adopted that child, she and I aren't married, so I have no actual legal connection to this kid whatsoever, but he lives under my roof. And so I then provide some care for him because we live together. And frankly, I also help, my wages help to put food in the refrigerator. I stand in loco parentis to that child. So really, it's any child for whom I have some degree of potential sort of conceptual parental oversight. Spouses and registered domestic partners, siblings, step siblings, and foster siblings. That's a pretty big deal. Biological, adoptive, or foster parents, step parents, etc. Grandchildren, foster grandchildren, step grandchildren, grandparents and step grandparents, children of siblings of the employees, meaning nieces and nephews, siblings of the parents of the employees, i.e. your aunts and uncles, children-in-law, siblings-in-law, any of the family members listed above of a spouse or registered domestic partner, any other individual related by blood or whose close association with the employee is the equivalent of a family relationship. And then the final one, just for good measure, I get to designate one individual annually to be my family member for this purpose. So let's say that I am 23, male 23, I'm living with 3 or 4 roommates that are also single and male, and I decide I'm going to name one of my buddies as my designee, and that person's too hungover on Monday to go into work because they drank too much watching the Vikings lose on Sunday. The Vikings didn't play on Sunday, they played on Thursday. I'm assuming they're going to lose this coming Sunday, so the analogy holds. If all that happens, ultimately I can say, oh gosh, I've got to care for my poor ailing buddy because he's my designee. It's a broad definition of people for whom this time can be used, and so recognize that. We've got a couple of questions that have come in here real quick. How does ESST work for an employee without defined hours, for example, a coach? You are going to have to figure out some kind of hours equivalency. And that's the short answer of it. The statute doesn't say explicitly, hey, for these sort of inchoate types of employment, here's how you do it. It just basically says you've got to come up with some sort of equivalency and figure out the kind of hours the coach is actually working. There's not a good, easy answer to that. That could be through things like time studies. It could be through sort of practical assessments. If you are actually audited on it, you're going to have to explain how you came up with whatever system or metric you're using to identify the hours that the coach actually works. So it's not a good answer, but it is the answer. Can you have a maximum hours accrued under the ESST? Yeah, so you only have to, we'll get to that in a second. So we'll talk about maximum hours in a second. Is there an annual form we need employees to sign for the annual designee? No, but you can create one. So there's not an official form. There's not anything in the statute that says a form must be used. But I think if you're going to have somebody designate a designee, you want to have them sign something saying that. Now, I would not proactively put that out there. Hey, all employees, figure out some random person that is somewhat meaningful to you and have them be your designee. I wouldn't do that. You can, I just wouldn't. Let them come to you and say, hey, I took some time off for this person and I want to make them my designee. Let them come to you with that particular piece of information. All right. For absences of greater than 3 days, so anything less than that, your hands are tied. But for an absence of greater than 3 days, you can request documentation. If the person is taking time off for their own illness or health condition, or a family member's illness or health condition, you can require a doctor's note. Except if the employee or family member did see a doctor, or a doctor's note would impose an added expense, then you can only request the employee to provide written confirmation. Yeah, the reason I took time off qualifies. And of course, an employee is going to give you that. So you can request a medical note, but if the person didn't go to the doctor, or again, it's going to add additional expense, you can't make somebody get a doctor's note. If I'm gone for reasons that are related to my safety or a family member's safety, you can ask for a court record or a document signed by a victim services organization, a cop, an attorney, or an anti-violence counselor. If it's due to a work or school closure, so my kid's school is closed for a snow day, all you can request is a written statement from me saying, yep, school is closed. You can't ask me to provide a copy of the email I got from the district saying it was closed or anything like that. So your ability to get confirmation of the validity of a need for time off is pretty limited. Employees can carry over up to, and this gets to the accrual piece of it in the caps, up to 80 hours of ESST per year. Unless you've got a couple of different options here, which very few of our clients are going to do, but you might be able to. So again, I have to accrue up to 48 hours per year. You don't have to allow me to accrue more, and I have to be able to carry over up to 80. And so how would those are two different numbers. How do you get there? Well, if I don't use my time, I'm going to carry it over to the next year and continue to accrue. I might get up to 80 hours of total accrued time over the course of 2 or 3 years. If I'm just not using it very much, I'm going to get there. Once I hit that cap of 80, assuming you want to impose that cap, you can use a higher one if you choose to. You're not required to. But once I hit that cap of 80, then you can stop accruing for me. We'll talk about PTO later because that's well, I shouldn't talk about it now, as I see on the slide. There are a couple of exceptions to that 80, if you want to do things differently, you can front load 80 hours, from year to year to year, which means you're not really carrying over anything. You're just front loading it each year, but that's more than 48. So a lot of our clients may not want to do that. You can also pay it out at year end in full, and then front load 48. There are various options, as you can see there, but most of our clients are just allowing it to carry over because it's easier, or doing a front loading of 80. Existing policies, including PTO. So if you have an existing vacation sick rubric, your sick policy can now become your ESST policy. You're just generally expanding the number of reasons it can be used and some of the protections that go with it. If you have a PTO policy, that can also substitute. And I'm just going to give a quick example here. So with PTO, typically PTO can be used for any reason on the planet. Doesn't matter what it is. My own sickness, my family member's sickness, a vacation day, I want to go shopping, whatever. I got to use it. You don't care. Ultimately, that's fine. But a couple of things are true. With PTO, a lot of our clients are not giving PTO to certain categories of employees. ESST applies to everybody. Part-time, full-time, casual employees, whatever. So if your PTO policy doesn't currently cover everybody, you're going to have to either expand your PTO policy to cover everybody, or keep your PTO policy as it is and create a separate ESST policy for those limited employment categories that you don't want to offer PTO to. So again, casual or maybe part-time employees, if you want to do that, you can have two separate policies, one for most employees and then this limited ESST one for just these. The second requirement for PTO, in addition to either applying to everyone or having a separate bucket, it has to accrue at least 1 hour for every 30 hours worked. That's usually not a problem for our clients, although sometimes it is for first-year employees of theirs. The third requirement is that people can't be punished for using PTO time that was, for ESST purposes. You can't have it count against their attendance, for instance. And so that means, you may want to keep some track of the reasons why people are gone, or give people a free 80 hours of time off before you start to impose consequences. And the last thing is just more practical thing. PTO can be used for any purpose. A lot of our clients' employees look at PTO as being essentially a vacation policy. And so, people may use all that PTO for, they're going to take 2 or 3 vacations during the year. If they do that, fine. If they then have a need for ESST and they've exhausted all of their PTO for vacation purposes, then they're just out of luck. So They don't have an additional right to time off, because they use the time for pleasure, and now they have an ESST needed reason. The only thing the state cares about is, did you give them enough time? Did they accrue at a fast enough rate for them to be able to use for that purpose had they chosen to do so? And if they didn't choose to do so and they use it for other purposes, then they're just out of luck. An employer notice, you're required to give an individual notice in the employee's primary language. The notice is also supposed to be included in the handbook. The DOLI is going to put together those notices in the languages, kind of like with the wage theft notices for those that remember those. You also are going to have to include on the pay stubs the available ESST that each employee has and the ESST that was used during that pay period. That begs the question about PTO. If PTO can be used for any purpose and you're not separately identifying within the PTO rubric what time has been used for ESST and what time hasn't, what do you do? What do you put in the pay stub? We don't know yet. I suspect the state will do much like the city of Minneapolis does. The city of Minneapolis has a similar requirement. ESST is supposed to go on the pay stub. I suspect the state will do what the city is, and the city has said, if you're using PTO, you don't have to track the ESST separately. You don't have to identify in the pay stub, just to put on there the amount of PTO that somebody has. Let that PTO and how much they've used in the past pay period, that's going to be sufficient. So I suspect the state will do that, but we don't know yet. Okay, and so going back to the question about, can you have a maximum hours accrued under the ESST? We currently accrue sick time up to a max of 600 hours. That's a generous accrual, by the way. Yeah, nope, that's well above what the SST requirement is, because 80 is the max that you have to allow people to accrue or to have in their buckets over the course of time, and they don't have to be allowed to roll over anything beyond 80. So your 600 hours is significantly above that. All right. So that was a fairly quick run through on ESST. Didn't feel like it to some people, but trust me, there's a lot of moving parts there. Let's move on to some other stuff. We're going to close out with paid family leave, which I suspect will involve a lot of angst and hair pulling and other things on the parts of you folks as well, but we'll get there. So ESST is a big deal. It's coming up on 1/1 of 24, so you've got a few months in front of you to prep for it, but do decide what you're going to do. Pay history inquiries. So this is part of a larger national trend as well. You guys may have heard of things called pay transparency laws. The conceit behind these things is that historically, women have been paid, and the current number right now is 80 or 81 cents for every dollar a man makes in the same job. If you're a woman of color, that number goes down precipitously from 80 or 81%. And so these laws are trying to help redirect or correct some of those systemic and historical problems. Whether they're going to effectively do so and whether there may be better ways to do so, that's a whole different debate. But let's talk about this. Minnesota has not adopted yet a full pay transparency law. A pay transparency law includes, in addition to what we're looking at here, the requirement to actually post the full pay range for every position that you are hiring for. Minnesota has not done that yet. They talked about it, but they're not doing it yet. Maybe next year, maybe the year after, who knows. But one thing they did say is starting January 1st of 2024, so basically the same time that ESST goes into effect, although they're not related, you can no longer ask applicants or job offerees for what they are currently being paid or have historically been paid, or what kind of benefits they're currently receiving or historically have been receiving. Now, they can volunteer those things to you, but you cannot request that information. So the statute actually says employers shall not inquire into, consider, or require disclosure from any source the pay history of an applicant for employment for the purpose of determining wages, salaries, earnings, benefits, or the compensation for that applicant. Now, it sounds like there may be some of you, I don't know, if any of you are public employers, a lot of compensation information is actually a matter of the public record. So what the statute anticipates that it says, hey, if that's the case, compensation data that's a matter of public record can be viewed, but it cannot be used for the purpose of determining wages, salary, earnings, benefits, or other compensation for that applicant. So basically, what they're trying to get you to do as an employer, if the job should pay at rate X, then offer the job at rate X. Don't offer it at rate Y just because you can get somebody for cheaper than the job is currently graded to pay at. And if you think about it, that's how they're trying to rectify some of those historical inequities. If women are coming into a job earning less than men for the same position, and you're just going to offer the same pay rate to either men and women, that solves a lot of the problem. I don't think it's that simplistic. I think a lot of times the offer of pay that is made is subject to negotiation, and women are going to come in from a lower wage rate and thus come in from a lower bargaining position and ask for less. Men are going to come in at a higher pay rate and thus ask for more. So I'm not sure how much this is going to truly move the needle on that inequity, but that's what they're trying to get at. So you can't make these inquisitions. You are allowed to provide information. So say, hey, this job pays within this range, or this is the maximum amount of pay that's available. These are the benefits. You can share that information about the job that someone's applying for, and you can ask people what their expectations are with respect to wages, salaries, and benefits. What do you want to be paid? How much are you willing to work for? You can ask those questions. You just can't say how much are you currently getting paid. So that's what that restriction is. Next, now this is something where I'm going to guess most of you on this call probably are not going to be impacted by this in a significant way. But if you're a smaller employer and you're not currently offering some kind of retirement program, a 401k, a 403b, a SEP plan, something like that, we've got some kind of retirement opportunity for employees. The state is creating a state retirement program, something that you're going to have to automatically enroll your employees in unless they choose to proactively disenroll or opt out of the program itself. So private employers with 5 or more employees that don't sponsor or contribute to a retirement savings plan must enroll covered employees in the state-run retirement program. This, by the way, will start up on 1/1 of 2025. And it looks like it appears to cover private employers with 5 or more employees anywhere in the country. So if you've got, let's say you're headquartered in Wisconsin or Nevada or somewhere else, and you've got a single employee in Minnesota, well, that single employee is less than 5 employees, but you have more than 5 employees total across the country. That employee is going to have to be enrolled in this program unless you're offering a 40, some kind of retirement plan. Public employers are not covered, nor are private employers who haven't engaged in business in Minnesota in the past 12 months. So that second piece there shouldn't affect any of you. Minors aren't covered, nor is anyone who's covered by the Railway Labor Act or a Taft-Hartley plan. So just keep that in mind. There are some exceptions to this. The program is funded by employee contributions. Not employer, but employee contributions. The contribution rate will be determined by the program board that's overseeing this thing. Employee contributions immediately vest. There's not going to be any kind of waiting period before they do so. And like I mentioned before, enrollment is automatic and required, but employees will have the annual opportunity, or more frequently if the board decides to come up with a different approach, to change and or cease their contributions. And then the board is also going to create a notice about this that employers are going to have to provide to employees 30 days prior to the first payroll deduction. Again, you can be exempted from this if you have a 401k, 403b, some kind of retirement program. I suspect the state will come up with a process for registering to say that you have such a program so that you are exempted from it, but we don't know that yet because there's a lot of runway between now and 1/1 of 2025. All right, that finally gets us to the paid family and medical leave. So let's take a step back here. This too is part of a larger national trend. The Federal Family Medical Leave Act provides up to 12 weeks of time off for the birth or adoption of a child, my serious health condition, the serious health condition of my spouse, parent, or child, and then a couple of military-related things. It's unpaid time. So I have a right to leave, and I have job protections for that leave, but I have no right to pay. If you've got short-term disability that applies or PTO or whatever else, I might be able to use that, but I have no right to be paid outside of those particular programs. So this is going to be, much like unemployment, a state-run program where I'm going to have a right to get a certain amount of wage replacement to cover leaves that would otherwise, as defined within this law. So it actually will run a lot like unemployment. It's going to be actually handled by the Department of Employment and Economic Development, DEED, which also runs unemployment. So what this provides for PFML, it provides for up to 20 weeks of leave and wage replacement benefits per benefit year. That's a big deal. 20 weeks is longer than 12, which is the federal FMLA. The benefit year for a private plan is going to be the same that you use for your FMLA, basically, if you're large enough. And for a state plan, it's going to be based on the account establishment. The details will come out about that later. Employers cannot penalize employees for exercising their rights, meaning employees have a right to reinstatement for these leaves. So this is actually creating a job-protected leave right in addition to wage replacement that didn't exist before in Minnesota. The right to reinstatement doesn't kick into play until 90 days after the date of my hire. But if you think about it, 20 weeks is longer than 90 days. Um, Ultimately, all employees are going to have protections under this pretty quickly by the looks of it. It can be taken intermittently for all forms of protective leave, including bonding. So under the Minnesota Parental Leave Act, as currently written, and under the Federal Family Medical Leave Act, I don't have a right to use FMLA or MPLA intermittently to bond with a child. I can use it intermittently for other purposes, but not to bond with a child. This leave can be used intermittently. So if I want to take 3 weeks of time off in the connection with the birth of my child, come back to work for say 9 more weeks, and then when my wife goes back to work, I want to take off another 9 weeks of time at that point, to prolong the period of time before my child has to go into daycare. That's intermittent leave usage. Under the FMLA, you wouldn't have to give it to me. Under PFML, you would. Um, Almost all employers employing anyone in Minnesota are going to be covered regardless of size. So if any of you have fewer than 50 employees and thus aren't currently covered by the Federal Family Medical Leave Act, you are covered by PFML. So you are now going to have a set of responsibilities that before this time you did not have. The exception is for employers of the federal government. So if you're a state employer, you're covered by this law, and some self-employed individuals, which should be generally irrelevant to this conversation. All employees are covered regardless of full-time or part-time status if they perform 50% or more of their work in Minnesota, or perform some employment in Minnesota but reside in Minnesota for 50% or more of the year, or perform no work in Minnesota at all, but Minnesota is the place from where their employment is controlled or directed. So you're a Minnesota-based employer, you've got an employee working remotely in Arizona. That person reports into Minnesota. That Arizona employee has rights and protections under this law and can get benefits from the state of Minnesota if they need a leave that's covered. There is a single exception, other than federal governmental employers. The single exception is for seasonal hospitality employees working fewer than 150 days per year. So hospitality is typically sort of catering, restaurants, that sort of thing. So if I work in seasonal hospitality fewer than 150 days per year, I don't have rights under this particular PFML. So if you employ individuals like that, you're going to have to make an application to DEED to say, hey, we've got this group of employees who isn't going to be covered because they check these boxes, and get DEED to bless that exception. Everyone else is covered, and if you don't submit that application, so too will your hospitality employees be covered. The scope of coverage and the leave protections provided are much broader than existing FMLA, MPLA, et cetera. I've already made some allusions to that. I'll give some examples here in a minute. And yes, the slides will be available. Both Rana and or Clyde, we're going to be sending them out after today's session as a PDF. Next, we have a few more slides to go through here because there's a lot to know about this. Now, and by the way, before any of you start clutching your pearls too much or grasping your heart, having palpitations or whatever, 2026 is really when this is going to go into full effect. There are a few things that go into play sort of in November of 2025, but the real full swing of this isn't until at least a couple of years down the road. So there's going to be a lot more to come and a lot of time to prep, but just recognize this is on the horizon. So what are the benefits that I get? Why is it that I can take leave? I can take leave from my own serious health condition, which includes inpatient care, continuing treatment or supervision by a healthcare provider, and telemedicine visits count for this purpose. Continuing treatment includes 7 or more days of incapacity with treatment 2 or more times within 30 days of incapacity onset. Under the FMLA, for those of you that are covered by it, the standard is 3 or more days of incapacity. So this is a slightly higher bar than under the federal FMLA. Incapacities due to chronic health conditions or long-term or permanent conditions are also covered. Those are typically intermittent type absences, and absences to receive multiple treatments and recovery therefrom for restorative surgery or a condition that would result in 7 or more days of incapacity if not treated. So those things are covered as a serious health condition. I also get to take time off for medical care related to pregnancy that includes prenatal care, recovery from childbirth, recovery from a stillbirth or a miscarriage. So I get some time to take off in connection with miscarriages and stillbirths as well. Family care to care for a family member's or a military member's serious health condition, and I will have the definition of family member coming up here in a second. Bonding, so I can take bonding up to 12 months after the birth of a child. Whether I'm the birth parent or the non-birth parent, I still have this right. Now, if the baby remains in the hospital longer than the mom, then ultimately that 12 months extends beyond 12 months after birth, but ultimately that's essentially the standard. And it can be used for time off in connection with an adoption as well. Um, Safety leave, I can also use it for that purpose. So if you remember the ESST law, earned sick and safe time, I can use it for safety reasons related to my own or my family members' domestic assault, sexual assault, or stalking scenarios, much like ESST. And then finally, I can use it for qualifying exigencies arising from a family member's military active duty service. The FMLA has a similar type of protection, although very, very few of our clients have had to deal with that, but that also exists. Quick pause point here. I've had clients ask me this already. How will ESST coordinate with PFML? Don't know. The two statutes are two separate statutes entirely. There isn't any cross-pollination except for some of these definitions are similar. We don't know yet. I'm sure as this gets closer to 2026, we're going to get guidance from the state. We'll talk about exactly how those things interact. I have some thoughts on it. I believe I know what they're going to do, but I don't know that yet. I will say this, and we'll see this coming up on a slide. The benefits that are paid through PFML, they are not 100% of my wages. The calculation is very similar to the way that they calculate unemployment. It's up to 50% of my current wages that caps out at whatever the state's current weekly max happens to be. So most people are not going to make anything near what they're currently making now. And at most, they're going to make 50% of what they're making now. And then they may well make less than that, and it'll probably be taxed as well. So it is a wage replacement benefit. It's not as generous as one might think it is. But we'll get to that in a second here. So the family members for whom leave can be taken include spouses, domestic partners, children, including in loco parentis, legal guardians, and de facto parents, which is actually in the law, parents and legal guardians, siblings, so brothers, sisters, grandparents, including the spouse's grandparents, grandchildren, and sons and daughters-in-law. So this is more expansive than the Federal Family Medical Leave Act. I can also take it for quote, and this is actually from the statute, an individual who has a relationship with the applicant that creates an expectation and reliance that the applicant care for the individual, whether or not the applicant and the individual reside together. So if I've got an invalided uncle, for instance, we don't live together, but I check up on my uncle, with some frequency, I stop by his apartment and whatever else, that probably fits that definition too. So let's put this on pause. I said briefly that the Federal Family Medical Leave Act, and that's the thing I'm going to compare us to here for this purpose, covers time off for the serious health conditions of my spouse, my parent, my child. Parent and child also includes in loco parentis, but spouse, parent, child, that's it. No grandparents, no siblings. A lot of the things that are on here are not covered by the Federal Family Medical Leave Act. So I might have a right to take time off for PFML purposes. I may take off 12 weeks for that. And then I may subsequently have a need for Federal Family Medical Leave Act time off. So let's say I'm pregnant, birth of a child kind of thing. So I take time off earlier in my pregnancy for my grandparents, who's now in hospice care. I use 12 weeks up, as grandma's slowly passing away. I come back to work. 3 months later, I have my child. I still have a full 12 weeks of legally protected time off to take under the Federal Family Medical Leave Act, if you're covered, and or Minnesota's Parental Leave Act. So I may have an awful lot of legally job protected time off because the PFML is more expansive than the Federal Family Medical Leave Act and Minnesota Parental Leave Act. When I'm taking time off that's covered by both laws, PFML and FMLA, or PFML, FMLA, and MPLA, they will run concurrently. Not consecutively, but concurrently. But there are times where my leave will count as one of those things, but not the others. Most benefits eligibility, not always, bonding, for instance, would be an exception, requires a 7-day qualifying event period. So there's basically a waiting period before benefits kick in. That's not true for bonding, which is not subject to that qualifying event or waiting period requirement. I can choose to use my sick vacation or PTO in lieu of my PFML benefits. And if I do so, I'm still subject to the job protections of the law. You cannot make me use my sick vacation or PTO in lieu of PFML. Now, why would I do that? Well, because sick vacation PTO pays at a much higher rate than PFML does. One of the things you're going to want to think about is this next bullet here. You can choose to provide supplemental benefit payments. So you can, if I want to designate my sick vacation or PTO as a voluntary supplemental benefit payment, hey, I want to use my PTO to supplement my state payment from the PFML program so that I get made whole. I can do that. So it can be a supplementary payment. And like I mentioned, interaction with the SST is unclear. I'll talk about the taxes here in a second. So there are also, as are many of the laws we've talked about, employer notices that are required. You're going to have to post an official notice that Deed is going to create at some point in English and the primary language of any group of employees, 5 or more employees, or independent contractors that you have that don't speak English as their primary language. So you may have multiple posters that you're going to have to put up. You're also going to have to give people notices of their rights under this law within 30 days from the date of hire or 30 days before premium collection starts to occur. That notice is going to be an individual written notice in the primary language of the employee that includes all the things you see in these sub-bullet points. Deed will come up with that form, that notice, so more to come there. We're going to talk about the premiums here, I think, on the next slide, so sit tight on that, and I'll get to this question that just popped up in a minute too. Pay stubs are going to have to reflect any premium deductions or amounts paid by the employer that are going into this program. And getting slightly ahead of myself, the premium payments for this are going to be at minimum 50% employer paid. You can choose to pay 100% of the premiums, or a minimum of 50% with employees taking up the remainder of the amount that you're choosing not to cover at 50% or above. That's on the next slide. Employee notice to employers. So the employees can be required to provide notice at least 30 days in advance of a foreseeable leave. This will be something you'll put into a policy, by the way. As soon as practicable for unforeseeable leave. So if I suddenly fall ill or my grandparent does, you have to give notice as soon as practicable. And as soon as practicable if my need for leave changes. So I'm taking currently 1 day a week off for the next 6 weeks, but I'm now going to have to start taking 2 days a week off. I have to give you notice of that as soon as practicable as well. I can be required, just like in Canada, the Federal Family Medical Leave Act and Minnesota's Parental Leave Act, you can require me to follow your normal call-in and reporting procedures. So whatever those are, I can be required to follow those. And if I don't follow those, you can discipline me for not following them, even though my leave itself may be legally protected. But you can only do so if you consistently discipline people for not following your call-in procedures. And much like ESST, you cannot require me as a condition of using this time to find my replacement before I have rights of access to the benefit and the protections that come with it. All right, last, I believe, couple of slides here. I've got a quick question. Is there a length of time a person has to be employed before they can qualify for PFMLA? No. In the first 90 days of of employment, they don't have a right to job reinstatement, but they have an immediate right to access to the benefits from the state program. So there's no waiting period, there's no length of employment. Full job protections kick in after day 90 of employment, but I still have access to the wage replacement benefits through the state fund, even from day 1. Benefits will be managed by Deed, which I mentioned already. Employees will file claims directly with the state. You are not, with an exception we'll get to in a second, you don't have to be part of that process at all. The amount of benefits paid is going to be determined by a formula that uses the employee's base wages up to a maximum equal to the state's average weekly wage. For 2023, that average weekly wage is $1,287 per week. That'll go up in 2024 as pegged to inflation. Benefits received are taxable and are reduced by any PTO that is used. So recognize that's the amount that I might get paid at. The way we pay for this is via a payroll tax of 0.7% up to the FICA annual maximum. Now, for those who aren't familiar with that, so for my wages, for everyone's wages, you have to do FICA withholdings for those wages, and employers also have to pay their FICA contribution as well, but you only do so on the first $160,200 of wages. For all wages above that amount, FICA contributions are no longer taken. There's a lot of fight at the federal level to change that, but anyway, that's what it currently is. That number varies from year to year to year. So the same thing here, you're going to have to take 0.7% of my wages are going to go into this fund. Employers can cover the full amount of the tax, like I mentioned, or can take up to 50% of the tax from employee wages. So you can pay it in full on behalf of employees, or you can split the cost with employees as long as you pay at least 50%. If you have fewer than 30 employees, you're going to have a lower tax rate that's going to be determined by the board. So that we don't know what that is. I mean, I actually think there's a formula for it, but either way, you're going to pay something slightly less than that. But for most employers, it's going to be that 0.7% of wages up to $160,200, the first of those wages. You can, if you wish to, in lieu of participating in the state-run program, you can substitute a private plan, but you have to seek approval from the state in order to do so. So why would you do that? Let's say that you are a multi-state employer and you have a short-term disability plan and that's offered to all employees. Um, and rather than saying, hey, our Minnesota employees are no longer going to be part of this, you want to actually substitute that STD program in lieu of the state's program. You can do that if the following conditions are met. First off, you're going to have to get an approval from the state, and you're going to have to pay a fee to get their approval because, well, of course you will. That plan has to provide benefits that are equal to or superior to those that are available through the state itself. Most short-term disability is not available for the serious injuries and illnesses of other parties or for safety purposes like stalking and domestic violence. STD is typically for my own serious health condition and the limitations related thereto. You're going to have to expand your short-term disability program to cover those additional things, including time off for bonding, etc. I think the various short-term disability providers out there are going to provide those additional supplements. They're doing it for New York already now, for instance, and some other states too. So it can be an option. You can also choose to say, hey, you know what? There's the employee-specific leave needs and the family member leave needs. We're going to have our private plan cover the employee piece, but use the state's program from the family or vice versa. So you can split the baby and do it half and half. Again, it'll be a strategic decision. You'll have to look at your costs and see what makes the most sense from a cost perspective. If you split the difference, the amounts you're going to have to pay, rather than being 0.7%, will be only 0.4% if you're participating in the med program alone, or 0.3% if you're just participating in the family benefit program alone. So again, you'll want to do some math on this to decide what's going to make the most sense if you're currently offering an STD program that has an expansion opportunity. Successor employers, if you have a plan that's been substituted in lieu of the state's program. So if you're an acquisition, the company that buys you is going to have to maintain your private plan for at least 90 days before getting rid of it or converting to theirs. And then last but not least, and we'll call it a day here. Got a question here. Is there a length of time? No. Can we hire employees in summer for 8 weeks to help with the summer care program for elementary kids? Can they take time off under the PFMLA? Yep, they can. The short answer to that question is yes, they can. Much like the FMLA, health insurance benefits must be maintained. That's either something you need to worry about or not. So you can require people to continue to pay their portion of the premiums. So if they're gone for 12 weeks, for instance, you can require them to keep paying their premiums as you could under the FMLA, or you can cover their premiums and then collect them in arrears when they return. If they're getting paid by the state, you can have no wages to collect their premiums from, so you might want to consider that. If you are a private employer with a health insurance plan that is self-funded, and you're not a church, ultimately ERISA is a federal law going to apply, and ERISA preempts state law. So you wouldn't necessarily have to maintain health insurance benefits for a PFML absence if you are a private employer that has a plan in place that ERISA covers. You'll probably do so because you would probably do it for the FMLA anyway, and many times these leaves are going to run concurrently, but just to recognize ERISA does preempt state laws that try to impact or regulate the management and performance of employee benefit plans. And then last but not least, and there's one last question here, effective dates for PFML are November 1st of 2025 for some of those job protection things, and then January 1st of 2026 for the actual receipt of benefits, etc. So a lot of runway in front of us, like I mentioned. Start thinking about this. The last question that I've got on here before I say one summative thing here, what's the start date on ESST? January 1st of 2024. So coming up in what, about 3 months and 10 days or so. Couple things by way of close. So that's a lot of stuff that we just went through. It's a lot of stuff that you need to know. Most of these things have some kind of, strike that out, most have a notice requirement that goes along with them. A poster, individual notices, things to put in handbooks. There's going to be a lot of that administrative work you're going to want to think about doing. Several of these things are going to require strategic considerations. If you are currently using non-competes, what do you want to do about them? Do you want to just remove them and can stick with the non-solicitations and confidentialities? Do you want to revisit that entire process? Drug testing is going to change if you're doing it pre-employment, in connection with cannabis. What does that mean for your practices currently? ESST, how are you going to coordinate that with the existing leave approaches that you currently are offering to employees? There are a lot of different decisions to be made there. And frankly, PFML is on the horizon, albeit down the road. Planning for that, especially if you're a smaller employer that heretofore has not been covered by the FMLA, this is going to be a seismic shift in your responsibilities and legal obligations. So the very last thing I'll say, and then I will finally shut up and let you all go about your days. A lot to consider here, a lot of decisions strategically to be made. Compliance is going to be important because I think we're going to see a lot of enforcement activity because that usually accompanies lots of changes to the law. Which gets me to my close. Thank you for giving us your time. I very much appreciate this. Yes, the slides will be available. Rana and or Clyde will be sending them out as a PDF here. Thank you for our time and having us be part of this. I hope this was useful to all of you. If you have follow-up questions, you can reach out to the folks listed here. And I hope everyone here has a great rest of the day. Rana, do you want to say anything by way of close? You're still on mute, by the way. Still on mute, so we'll say that no. Everyone just gets to go. Thank you, Rana. Thank you, everybody. Have a great rest of the day.